case briefs, and so much more. LSData's got what you're looking for.
In 1936, the United States Court of Appeals for the Ninth Circuit heard the case of Hinman v. Pacific Air Transport, which centered on the ownership of the airspace above a landowner's property. The case involved two landowners who claimed ownership of the airspace up to at least 150 feet above their land. They filed appeals against Pacific Air Transport and United Airlines Transport Corporation, alleging that the airlines trespassed on their property by flying aircraft at low altitudes. The landowners asserted that they owned 72 acres of real property in Burbank and the corresponding airspace, which they believed they could reasonably utilize up to an altitude of 150 feet. They claimed that the property's value was in excess of $300,000 and requested that the airlines cease flying through their airspace. The lower court dismissed their claims and the landowners appealed the decision. Ultimately, the Court of Appeals ruled that a landowner's claim to ownership of the airspace above their land is limited to the extent necessary for the use and enjoyment of the land, with the rest belonging to the public. The court rejected the ad coelum doctrine, which had been used to support the landowner's claims, stating that it was unsupported by law or common sense. The court also ruled that an easement in the air could not be obtained by prescription, noting that the airspace overlying the land is generally considered valueless. Due to the failure of the landowners to demonstrate damages caused by the airline's actions, the Court of Appeals upheld the dismissal of their case. This decision solidified the legal understanding that landowners have limited ownership of the airspace above their property, with the remainder falling under public domain.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of climb.